Hello everyone, my name is Shashank and you're watching iSharKy. So guys, in today's video, we are going to discuss Article 16, Equality of Opportunity in Matter of Public Employment. Article 16 Clause 1 guarantees equality of opportunity to all citizens in matters of employment to any office under the state. According to the Article 16 Clause 2, no citizen can be discriminated against or be ineligible for any employment or office under the state of grounds only of religion, race, caste, sex, descent, place of birth, or residence. These two clauses thus postulate the universality of Indian citizenship. Article 14 guarantees a right of equality. In general, Article 15 and 16 are instances of the same right of equality in specific situation. Article 14 and 16 supplement each other. Article 16 deals with a very limited subject, mainly public employment. What Article 16 guarantees is that all citizens in matters of state service shall be treated alike under like circumstances, both in privileges and obligations. Discrimination is a double-edged weapon. It would operate in favor of some persons, but against some others. Article 16 Clause 2 prohibits discrimination, thus assures the effective enforcement of the fundamental rights guaranteed in Article 16 Clause 1. Article 16 uses the term office, which means subsisting, permanent, substantive position having an existence independent of the persons who fills it, which is filled in succession by successive holders, and which has more or less a public character to which duties are attached. The equality guaranteed by Article 16 takes within its fold all stages of service. The expression matters relating to employment, in employment both prior and subsequent, which are incidental to the employment and form part of the terms and conditions of such employment, such as salary, periodical increment, leave, promotion, fixation of seniority, gratuity, pension, superannuation, and even termination of employment. Let's take some case laws here. In Randhir Singh versus Union of India, difference between salary of driver constables in Delhi police force and other drivers in the service of Delhi administrations has been held to be irrational, as there is no reason to give driver constable a lower scale than the other drivers in spite of fact that the duties of driver constables are more onerous than those of other drivers. In ABSK Sangh versus Union of India, the Supreme Court again went into the questions of reservation. The court held that since SCs and STs suffer from socio-economic backward status, the fundamental right of equality of opportunity justifies categorization of SCs and STs separately for the purpose of adequate representation in state services. This is constitutionally sanctioned in forms as Article 16 Clause 4 and Article 46 specification. The majority opinion of the Supreme Court on various aspects of reservations provided in Article 16 Clause 4 may be summarized as follows. Number 1. Backward class of citizens in Article 16 Clause 4 can be identified on the basis of caste and not only on economic basis. The majority held that caste can be and quite often is a social class in India, and if it is backward socially, it would be a backward class for the purpose of Article 16 Clause 4. Although urbanization has to some extent broken this caste occupation relationship, yet it is still predominant in rural areas. The court said that the procedure and method of identification must be left to the authority appointed to identify backward classes, because the constitution is silent on the method of identification, and neither it is possible for the court nor admissible to lay down any such procedure or method. Caste will have to be considered among and only with other criteria as a test of backwardness. Number 2. Article 16 Clause 4 is not an exception to Article 16 Clause 1. It is an instance of classification. The court accordingly overruled its decision in Balaji versus State of Mysore, which it was held that Article 16 Clause 4 is an exception to Article 16 Clause 1. The court approved the decision in State of Kerala versus N.M. Thomas, where it was held that Article 16 Clause 4 is not an exception to Article 16 Clause 1, but a facet of doctrine of equality enshrined in Article 14 and permits reasonable classification just as Article 14 does. Number 3. Backward classes in Article 16 Clause 4 are not similar to socially and educationally backward in Article 15 Clause 4. Article 16 Clause 4 does not contain the qualifying words socially and educationally, as does Article 15 Clause 4. The backward classes of citizens in Article 16 Clause 4 takes in SCs and STs and all other backward classes of citizens, including the socially and educationally backward classes. Thus, certain classes may not qualify for Article 15 Clause 4, but they may qualify for Article 16 Clause 4. Accordingly, the court overruled the Balaji case on this point, in which it was held that the backward class of citizen in Article 16 Clause 4 is the same as socially and educationally backward classes, scheduled caste and scheduled tribes mentioned in Article 15 Clause 4. Number 4. Creamy layer must be excluded from backward classes. The court directed the Government of India to set up a commission within 4 months from the date of decision to specify the basis of the relevant and requisite socio-economic criteria to exclude socially advanced persons, that is, the creamy layer, among backward classes. The court held that the basis of exclusion of advanced sections, that is, the creamy layer, from other backward classes for the purpose of reservations should not be merely economic unless advancement is so high that it necessarily means social advancement. Number 5. Article 16 Clause 4 permits classifications of backward classes into backward and more backward classes. On this point, the court overruled the Balaji case, in which it was held that the subclassifications between backward classes and more backward classes was unconstitutional. In the Mandal case, the court held the classifications is necessary to help the more backward classes, otherwise the advanced section of backward classes might take all the benefits of reservation. Point number 6. A backward class of citizens cannot be identified only and exclusively with reference to economic criteria. It was held that it would defeat the very object of Article 16 Clause 4 to give adequate representation to backward classes in the employment of state. Article 16 Clause 4 is not aimed at economic upliftment or alleviation of poverty. It is specifically designed to give a due share in the state power to those who had remained out of it mainly on account of their social and therefore educational and economic backwardness. Point 7. Reservations shall not exceed 50%. However, in an extraordinary situation, it may be relaxed in favor of people living in far-flung and remote areas of country who, because of their peculiar condition and characteristics, need a different treatment. But in doing so, the court said that extreme caution is to be exercised and a special case made out. Article 16 Clause 4 speaks of adequate representation and not proportionate representation. Point 8. Reservation under Article 16 Clause 4 can be made by an executive order. It need not to be made by the Parliament or the legislature. Number 9. The court held that the reservation is confined to initial appointment and there shall be no reservation in promotion. Such reservation may continue for a period of 5 years from the date of this judgment. This is consistent with the object enshrined in Article 335. At the initial stage, reservation can be made from them, but once they enter the service, efficiency demands that these members to compete with others and earn promotions like others. Number 10. There would be a permanent statutory body to examine complaints of over-inclusion and under-inclusion of groups, classes and sections in the list of backward classes. Within 4 months of Government of India shall specify the basis applying the relevant and requisite socio-economic criteria to exclude socially advanced sections, that is, creamy layer, from the other backward section. Number 11. The court did not express any opinion on Mandal Commission report. The majority held that, in view of guidelines laid down in its decision, there is no need to express any opinion on the correctness or adequacy of the exercise done by Mandal Commission. Number 12. Disputes regarding new criteria can be raised only in the Supreme Court. National Commission for Backward Classes. In March 1993, the Parliament passed the bill setting up a National Commission for Backward Classes. The Commission is a statutory body and therefore it would enable it to comply with directions given by Supreme Court in Mandal case. I hope you like this video. Please make sure to subscribe and press the bell icon. And also share and like this video